Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court has significantly ruled that Bar Council of India is empowered to prescribe qualification of All India Bar Examination (AIBE) as eligibility criteria for practicing in the legal profession. A 5-judge constitution bench ruled that it is within the BCI's domain to decide whether the exam will be conducted pre-enrollment or post-enrollment. The court overruled V. Sudhir versus Bar Council of India, in which it was established that no condition other than those enumerated in Section 24 of the Advocates Act could be imposed on a person willing to practice law. The bench, comprising of Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice A.S. Oka and Justice Vikram Nath and Justice J.K. Maheshwari, found that Advocates Act confers adequate powers on BCI to prescribe norms for entry to the legal practice and thereby approved of the constitutional validity of the AIBE. Additionally, the bench called for an appropriate rule to be framed, laying down that an enrolled advocate who takes up employment in non-legal context for a substantial period would be deemed to be a new enrollee and would be required to take AIBE again. The Supreme Court dismissed a PIL filed by Hindu Sena seeking ban on a BBC documentary centered around Prime Minister Narendra Modi, questioning his involvement in the Gujarat riots of 2002. The British Broadcasting Corporation (BBC) has recently aired the documentary India, the Modi Question on 2002 Gujarat riots, which has been banned by the central government across all social media and online channels, citing national interest. A division bench of Justice Sanjeev Khanna and Justice M.M. Sundaresh expressed astonishment on the petition and called it completely misconceived. Despite the centre's ban, the documentary has been screened in public gatherings in colleges and universities as a sign of protest against the censorship imposed by the centre. The documentary dives into examination of the Prime Minister's role in the heinous riots that took place when he was the Chief Minister of the state of the Gujarat. Apart from the ban, the petition sought probe into the alleged anti-India reporting by the BBC. The Supreme Court has dismissed petition in the controversial matter of appointment of Advocate L. Victoria Gowri as the judge of the Madras High Court, just as she was being sworn in, observing that it cannot examine suitability and can only delve into examining eligibility. A division bench of Justice Sanjeev Khanna and Justice B.R. Gavi observed that the issue raised in the petition pertains not to the eligibility of Gowri but her suitability, which is a subjective assessment, and hence the court would not be able to examine the same. The court further observed that entertaining the petition would amount to interference with the SC Collegium decision. The chairman of the BCI submitted that they have checked and there has absolutely been no complaints of misconduct against the person. Some bar members of the Madras High Court had written to the Chief Justice of India seeking recall of the recommendation made for the appointment of Ms. Gowri as an additional judge of the High Court, alleging that she made hate speeches against Christians and Muslims. Ms. Gowri's proposed elevation has been mired with controversy after reports of her alleged affiliation to the BJP has emerged. Noting that investors in Adani Group has suffered losses after the short seller Hindenburg research report, the Supreme Court has observed that there is a need to safeguard the investors. While hearing the two public interest litigation seeking a court-monitored probe, the Supreme Court bench chaired by CJI D.Y. Chandrachud and Justice P.S. Narasimha and Justice J.B. Pardiwala asked the Securities and Exchange Board of India (SEBI) to suggest measures to ensure protection of Indian investors after the short-selling report on Adani Group. Following this, the bench ordered the market regulator to file a response detailing how a more robust mechanism can be put into place. The bench also suggested on having an expert committee and also conferring wider powers on SEBI. Holding that it is the most fundamental duty of a secular state to protect the citizens irrespective of their religious belief, the Supreme Court has said that the government must show absolute zero compromise on hate crimes and express displeasure over the UP government for its reluctance to register a criminal case for robbery and hate crime on the complaint of a senior citizen who alleged that he was abused because of his religion. Noting that the alleged incident happened in Noida in July 2021, but FIR was lodged on January 15th of this year, just 2 days after the court asked the state to place before it the case diary. A bench of Justice K.M. Joseph and Justice B.V. Nagaratna said that there was a lack of will on the part of the state to prosecute the culprits. The court observed that the state police, instead of acknowledging the problem, tried to sweep it under the carpet. From doing away with the need for the judicial magistrate first class to check if the living will is executed voluntarily to simplifying the composition of the medical boards determining whether the life support system can be withdrawn, the Supreme Court has issued a simplified version of the procedure for passive euthanasia in India. A bench comprising of Justice K.M. Joseph, Justice Ajay Rastogi, Justice Aniruddha Bose and Justice Hrishikesh Roy and Justice C.T. Ravi Kumar agreed to make the process less cumbersome by modifying the existing guidelines it laid down in 2018 on living wills or advance directives. A living will or an advance directive is a document that a person can execute in advance explaining his or her wishes about withholding or withdrawing medical treatment in case of terminal illness and is undergoing prolonged medical treatment with no chance to recovery and cure. Next we have Delhi High Court. The Delhi High Court in a significant decision has held that conducting virginity test on a female detainee or accused under investigation is unconstitutional and in violation of a right to dignity enshrined under Article 21 of the Constitution of India. The single-judge bench of Justice Swarna Kanta Sharma observed that there cannot be two sets of views regarding the test of virginity being in violation of fundamental rights for a victim of sexual assault and a woman under investigation. It is not the issue of a person being a victim or an accused, but the vital issue is such as test being in violation of fundamental rights if conducted on a female, whether a victim or accused, the court ruled. The observation came in petition moved by Sister Steffi, convicted in 1992 Sister Abhaya murder case, challenging the virginity test conducted on her by the CBI as unconstitutional. The court said it will be difficult for it to hold that being guided by the constitutional principles of fundamental rights that a person in custody of the authorities surrenders the right to bodily integrity and submits to bodily intrusion for the prosecution to find evidences through its body. The Delhi High Court has expounded that merely because the petitioner was denied the benefit of budgetary support under the scheme of budgetary support under the GST regime at the material time, the same cannot be read as to mean that the petitioner was not availing the same. The court noted that the scheme defined the term eligible unit as a unit eligible before 1st July 2017 to avail the benefit of ab initio exemption or exemptions by way of refund from payment of central excise duty under notifications as issued in the regard listed in the scheme and was availing the said exemption immediately before 1st July 2017. The Delhi High Court has opined that the mark of Szechuan chutney has acquired secondary significance considering the advertisement and sales figure, and hence the order of the single judge refusing to grant an interim injunction to restrain the respondent defendant from using the mark Szechuan chutney was stayed. The Delhi High Court has approved of the request by the Delhi Police seeking urgent listing of the petitions challenging the discharging of the JNU students Sharjeel Imam, Safura Zargar, Asif Iqbal Tanha and 8 others in the Jamia violence case. The District Court of Saket had recently discharged the students in Jamia violence case of 2019, noting that the distinction between dissenters and rioters cannot be erased. ASG Arun Verma had strongly criticized the Delhi police and had made strong observation, alleging the police of filing misconceived charge sheet devoid of irrefragable evidence. He accused them of picking the students as scapegoats as they failed to probe the actual perpetrators. The students clashed with the police after announcing march to protest against the Citizenship Amendment Act and the National Register for Citizens. Now let's have an overview of other high courts. The Madras High Court, while interpreting Article 25 of the Indian Constitution, which provides freedom of conscience and free profession, practice and propagation of religion, held that it is not possible to put a blanket ban on the conduct of religious meetings. However, reasonable restrictions can be imposed in favor of the sovereignty and integrity of the country. The court observed that Article 25 of the Constitution provides freedom of conscience and free profession, practice and propagation of religion. Thus, a total ban cannot be imposed on the conduct of the religious meetings. The Madhya Pradesh High Court allowed criminal appeal filed by a person accused under the IPC and POCSO Act because the only evidence of a minority of the girl at the time of the incident provided by the prosecution was the date of birth mentioned in the school register. The court held that even though the school register entry was admissible, its probate value is very low, and to prove this age, since parents usually enter wrong date of birth of their children in order to get them admitted to the school. The Bombay High Court, while dismissing an application seeking anticipatory bail in an offence of outraging the modesty of a woman, observed that the case of the prosecution cannot be doubted just because there is a delay of 2 days in lodging the report. The court observed that in a case like that of outraging the modesty of a minor girl or sexual assault, there is always a reluctancy to go to the police station and lodge the report. The case of the prosecution therefore cannot be doubted just because there is a delay of 2 days in lodging the report. Prima facie, the defense of the applicant that a false report came to be lodged against him does not appear to be probable. The Orissa High Court has expounded that the proof of demand of bribe is the gravamen of the offences under Section 7 and Section 13(1)(d) of the Prevention of Corruption Act 1988. If such proof is not established, then the charge would fail. Mere acceptance of the amount allegedly by way of bribe or recovery thereof deholds the proof of demand ipso facto would not be sufficient for a charge under these sections. The court opined that mere receipt of the amount by the accused would not be sufficient to fasten the guilt, especially when there is no evidence regarding demand and acceptance of the amount as illegal gratification. The Madras High Court has held that exemption under Section 11 of the Pensions Act 1871 and under Section 61G of the Civil Procedure Code is not applicable to the husband because a wife is not creditor and the maintenance to her cannot be considered as debt. Hence, the maintenance to the wife was attached to the pension of the account of the husband. The court held that the maintenance allowance granted to the wife cannot be considered as a debt and she is not a creditor. And therefore, the exemption under Section 11 of the Pensions Act as well as exemption under Section 61G of the CPC cannot be granted to the husband. Moving on to miscellaneous news. The Supreme Court has agreed to consider transferring to itself an array of cases that have challenged the validity of the religious conversion laws framed by different states' governments, including Uttar Pradesh, Gujarat, and Madhya Pradesh. A bench headed by CJ D.Y. Chandrachud issued notices to the centre and the concerned state governments on a common transfer petition demanding all the cases to be clubbed together and decided by the top court in view of the common issue involved. An Indian princess who became famous for playing a leading role in the British suffragette movement is to be honoured with a blue plaque outside one of the homes she lived at in Britain. Sophia Duleep Singh was born in Punjabi royalty in 1876 as a daughter of the Maharaja Duleep Singh, the last ruler of the Sikh Empire. She was the granddaughter of Maharaja Ranjit Singh, founder of the Sikh Empire. Delivering the 19th Justice P.D. Desai Memorial Lecture, Senior Advocate Arvind Dattar shared his views on the National Judicial Appointment Commission Act, which is at the centre of the apparent brewing tension between the centre and the Supreme Court. The senior advocate has called the act as completely unworkable and has subtly advised the centre to rework it instead of taking aim at the Supreme Court for striking it down. Mr. Dattar strongly defended the principle of basic structure and remarked that it has never prevented any development effort of the government and is rather important for the protection of the Constitution. NJAC Act was struck down by the Supreme Court in 2015 on the ground that it undermines the independence of the judiciary, which is a part of the basic structure of the Constitution. The Supreme Court of India this week hosted the 73rd anniversary of its establishment. The top court came into existence on January 28, 1950, 2 days after India became Republic. Chief Justice of Singapore, Justice Sundaresh Menon, who is of the Indian origin, graced the occasion as chief guest. In his address, he hailed the Supreme Court of India as among the busiest courts in the world and the justices among the hardest working judges due to the immense workload they tackle. A 5-judge constitution bench referred for consideration of 9-judge bench question of validity of excommunication practice prevailing in the Dawoodi Bohra community in Muslims. The larger bench is thus tasked to decide the correctness of the first Sabrimala judgment. Dawoodi Bohras, which forms a section of Shia Muslims, provide their supreme leader with the power to excommunicate or expel members, thereby denying them access to the community, mosque or burial grounds as well as other facilities. The top court has reserved in October last year its verdict on whether to pass the issue to the larger bench in petition pending since 1986 challenging the constitutional validity of such practice permitting social boycott. The Finance Ministry has come out with a draft scheme for the settlement of pending disputes related to the government contracts. Under the Vivad Se Vishwas second contractual disputes scheme, the contractors would be offered settlement amounts depending on the status of a dispute. In the end, we have international news. Gearing up to tackle on the malicious allegations against the Adani Group, which were dubbed as the calculated attack on India, Chairman Gautam Adani has hired leading defence firm Wachtell in its battle against the short seller Hindenburg Research. The Adani Group has tabbed senior lawyers at Wachtell, Lipton, Rosen and Katz to advise it on how to stem the crisis facing the Indian conglomerate. Former US Vice President Mike Pence has been issued a legal summons to testify in a criminal investigation of former President Donald Trump. The subpoena is reportedly linked to Mr. Trump's bid to overturn his defeat in 2022 presidential elections. Department of Justice is also investigating Mr. Trump's handling of classified files. The subpoena piles pressure on Mr. Pence as he considers as a potential White House run against Mr. Trump in 2024. Failure to comply with such a summons could lead to a serious legal consequence. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.